Hello, my name is Malik Abazda. Welcome to PM Express. There was anger, frustrations, accusations, and counter-accusations in the camp of what has become a third force in Ghana's politics, and I'm talking about the Progressive People's Party. But when all was said and done, there were smiles. In court, when the High Court judge delivered the judgment that the PPP believed they rightly deserved. Where is the PPP going from here? What is the contribution of this decision to our democracy? When we come back from the break, I will introduce my guest who will settle for this discussion. Keep watching. Yeah, welcome back. My guests in the studio are Mr. Fred Oduro. He is a governance expert and he teaches at the Institute of Local Governance. Welcome. And then William Dorpo, he's a parliamentary candidate for the PPP for the Ayawas West Wogon. Gentlemen, welcome.
Thank you very much.
Let me start with William. And it's not surprising at all that you are in a nice white smoke. And
Dagomba smoke.
Dagomba smoke, yes, from the northern part of Ghana.
Yes.
Were you in court?
Of course I was in court.
And when the judge started delivering his judgment, what was going through your mind?
Well, I had gone to the court knowing very well, very clear in my mind, collectively, in fact, individually and collectively as a party, that we had been shortchanged, that we were not given opportunity in accordance with the rules of the game, that if your forms were found to have fallen short, you should be given opportunity to correct or apply some alteration to it so that it would fit the requirement for acceptance. We did not get that opportunity. So even from the layman's point of view, we're very clear that we had been shortchanged, and we were hoping and believing that the judge would do us justice.
But you were afraid?
Well, given some challenges that we had had, and given that this stone that had hit us was a strange stone, because normally this was just a matter of course, that you had submitted your forms and there was something wrong with it and you are called to come and correct it. This time around, we were not given the opportunity. So we were wondering, you know,
but
what's
sitting
going
in the
on?
courtroom, were you afraid whilst the judgment was being delivered?
No, not.
Were you anxious?
Oh, certainly. In fact, you know, I got there very early, and I should admit that it was one of the longest 1.5 hours that I've had in my life.
This is confession time.
Yes, no, I was anxious, you know, certainly, because I wanted this to get out of the way, you know, very quickly. But we had to get there early because we got signal that the court was going to be full, and if we're not there early, we're not going to get opportunity to, you know, have a seat and so on and so forth. But more importantly, we were expecting judgment in our favor today. And so we went there, although there was anxiety and all that, we're all prepared. Many of our people were in white, they had their white handkerchiefs and you know, white powder. And you should see our vehicles. It's all been plastered with white powder. Yes.
So you sit back and you watch all of these things play out. What would you say is a contribution of decisions such as these on our governance and democracy and our politics and all of that?
For starters, I'm very, very surprised because from the onset I've expressed the view somewhere else that I wasn't expecting the court to want to touch the cards this late hour, especially looking at 4 years back. There were a series of court cases, but the courts seem to have stuck with the EC on some of these decisions. If you remember, 4 years ago, there was this creation of new...
Yes. The new districts and the concomitant constituencies.
There were a lot of court cases, and the EC, the courts seem to have... They didn't try as much. They tried as much as possible to let the status quo remain. So personally, I'm very happy, but I'm mildly surprised because I thought the court might have gone that way. So for me, one of the things that I'm seeing is that this is a stamp on rule of law, and it can only enrich our democratic credentials as a country. It's a very good thing. Indeed, I must also add that I have a personally, I was very much worried that certain key people were going to be missing from the campaign train. People I've always found to bring a lot to the table. I won't discount Dr. Indium. Nobody can discount him. You can't discount Dr. Edward Mahama. So I am happy in one sense that there's an opportunity for Dr. Indium to come back. Mind you, let's be very careful. He's not come back. But there is now an opportunity to bring him back. But so let's see how the process is.
Yes, going. Because a judge stated that the EC should give him the opportunity which he complained he had been denied, and that if he makes the amendments and alterations and he resubmits it, his nomination form, they should then take it and then assess it and determine whether it meets the requirement. And given that the EC's own complaint was just about one person, Richard Asida, all of us can take it for granted. This is that he will be on the ballot. And you were talking about how you thought that the courts will not tamper with this. Does it surprise you also that just yesterday, the Supreme Court delivered another ruling which goes to the core of the elections, i.e., that collation sheets for the parliamentary and presidential candidates should be given to party representatives at the collation centers?
Yes, it must be signed by all the key parties, all the stakeholders, and then they should also be finished. You see, I think yesterday should also have given us an indication of the direction of the judiciary. Not that I'm saying there is a deliberate decision to go in a particular direction, but let us even go back to the Abu Ramadan, the last one. I think there are about three
Abu
now.
Ramadan, yes,
the
last clarification.
If you look at the posture of the Supreme Court, the kind of pronouncements that were made in the courts, it was sending a clear signal to the EC. And let me chip in here. I wasn't happy with a point made by the lawyers for the EC that it's an independent body and that nobody can compel them to change their decision.
Yes, that's one of Tadiasori's arguments.
I found that, it seems we've not had much discussion on that point, but I found that very interesting point, and I was very worried that, oh, so we have an administrative body that is, because it's supposed to be independent, even if it's in the wrong, the courts do not have the powers to even change, order it to go by what the law says. So I think all in all, it's not so much as where the decision has gone, but I think the rule of law has won the day, and it can only go to enhance our democratic credentials as a country.
Your party is the beneficiary of all of this. And I'm sure you would have followed yesterday's decision as well. And do you have a sense that the courts have decided to not play with the EC with kids' gloves?
Well, let me say that it is not only the PPP that has won. Democracy, the rule of law, constitutionalism have all won. And it goes to enrich our democracy. The EC's posture in context of its independence, I think the EC was operating the independence as a sword and not a shield. And so every now and then they will say we are an independent body. So whatever decision we take, good or bad, must stay. But we all know what happened with Abu Ramadan. The EC directed that names on the register should be deleted. And interestingly, in our matter, the counsel for the EC also raised preliminary objections. And one of them was that the EC was an independent body. Fortunately, the ruling made it clear that not so. You are required by law to operate in a certain manner. And the rules of natural justice in particular required that you heard the party before judgment. In our case, we were not heard. But what intrigues me is that in the course of making the case before the judge, the EC's lawyer tried to smuggle in the 5-minute engagement that Dr. Indum had with the EC chair. And he was trying to get the court to accept that as hearing.
I'll come back to
yes.
this because I will be picking parts, bits and portions of the judgments and then going through them. And I want us to listen to Dr. Papakusindum, who is benefiting immensely from this judgment. I'm sure
our democracy is benefiting.
So excited. Well, but he was the applicant in this matter.
Immediate beneficiary
of this.
Yes,
Let's listen to Dr. Papakusindum. He's a flag bearer of the Progressive People's Party. He's the presidential candidate of the party who was disqualified. He successfully challenged that disqualification. Let's hear him.
That have been restored by the courts today. And I'm very grateful, I'm very thankful to the judge for understanding the legal arguments that our lawyers have made. I'm happy for the Progressive People's Party and all of our supporters, and especially for the prayers that they have offered on my behalf. I thank everybody. We will have an opportunity later to talk extensively. For now, I'm just thankful, I'm just grateful.
Yeah, welcome back. And you just heard Dr. Papakusindum. He is a presidential candidate of the PPP. I still have with me William Dorpa, who is an excited person with his white smoke, enjoying the hope that this judgment gives. You were talking about Tadia Sori's argument, and Tadia Sori is a lawyer for the Electoral Commission.
Correct.
And his arguments about the 5 minutes that your presidential candidate asked for. You can't fault him for that because that's what you asked for, and you got that.
No, the main issue that were presented to the court was that we had been denied opportunity to be heard.
Yes,
and hearing in this context meant that you would be given back your forms which do not meet the requirements. So they are given back to you, and you have opportunity to apply some alterations to make it fit and acceptable to the Electoral Commission. We did not get that opportunity, and I think that is the main thrust of the matter. I'm sorry.
Yeah, but okay. So this is what the judge said. Let me read what the judge said. He said, to reduce the denial of fair hearing that the law affords the applicant before a decision is made to disqualify him, to the meeting that took place after the disqualification of the applicants, is to trivialize the weightier and substantial mandate placed on the shoulders of the returning officer to afford an opportunity to the applicant to amend his nomination paper within the nomination period before a pronouncement was made to disqualify him.
Yeah, certainly.
That's what you were referring to.
Yes, yes. So you know, you are required by your own rules to give opportunity. You failed to do that, and this 5-minute thing, which was meant to just tell you that, look, this is what it is, and this is how you should do it, but you refused. Okay. Now for the EC lawyer to raise that and say, indeed, the man was given opportunity, for me was very intriguing, and I think that the judge has described it in the best terms.
Yes, he said it was gravely pedestrian and peripheral. Let me go to Sodro. When you hear a judge refer to matters such as this and say the things that this judge was talking about, that referring to the lawyer's argument and said it was gravely pedestrian and peripheral, would you say the judge kind of was a bit emotional on this?
Well, I wouldn't say so, because if you have a good read of this judgment, you would agree that this is well written, well researched, and by and large, it's something that you can always refer to. Indeed, I also found it unfair to raise a 5-minute meeting after the fact, after the person has been disqualified. And even after the meeting, there was no opportunity afforded the individual to be back or to go and correct the errors, and to refer to that as having given the person an opportunity. I would have wished that bit of the argument had not come in.
But knowing this, why did you still hold the view that the courts would stay this decision of the EC?
Well, because my personal view, from what I could understand from the case prior to the judgment, was that within the period, you see, the operative word for me was within the nomination period. That was why I thought the court would not rule in favor of the applicant.
So I have to come to you. I have to talk to Mr. Yawopong. Mr. Yawopong is a lecturer with the Central University Faculty of Law. I believe that he can help us with some understanding of this decision. Mr. Yawopong, if you can hear me, good evening and welcome to PM Express. Hello, good evening.
Yes, good evening, but I can barely hear you.
Okay, I'll try and speak up. I say you must have followed with keen interest the High Court's decision on Papa Kwesi Ndum's application and the ruling, the judgment thereof. What are your preliminary observations of this judgment?
Well, thank you very much. I had the privilege of being in the court when
okay, great, that's better.
Was delivered, read. And well, I think that it's one of the best judge rulings you may ever have the opportunity to hear or read, in view of the expenditure of energy that the judge may have go through it with maybe throughout a number of nights, in view of the fact that this case was barely 2 weeks. And for a person to come out with a wonderful judgment, I think we may only have to add our voice to others and congratulate him and commend him, and the parties as well, the lawyers, and so on. So for me, it's a very good judgment. It just deepens our rule of law, the concept of good judgment that we are taking to ourselves.
What aspects of this judgment are for you outstanding and why?
Well, the fact that the judge was able to draw the line between what exactly judicial review out and what it is not about. Because for me, as a teacher of constitutional law and judicial review, one of the most important topics or subjects that we teach is really an important aspects. And we have seen it having Supreme Court decisions and High Court decisions, and obviously reviewing all the relevant cases. And it's quite gratifying that we continue to build on these 8 principles. And so it makes it for you to conclude that what happened today had nothing to do about the merits of the case. It had all to do with procedure that the EC affected, and not so much as to whether or not it was right.
Can we take it for granted that Dr. Ndum will be on the ballot paper?
Well, for me, I do not think that a decision as to whether or not he has complied with the law or he will comply with the law has yet been made. That wasn't the concern of the court today. What concerns the court today is about whether or not the EC adopted procedure in coming to their decision to declare the application void, and for that matter, non-compliant with the appropriate rules in terms of CI 94.
The judge used some words and expressions, some would say, were, for want of a better expression, quite uncharitable towards the EC's lawyer. He used words such as gravely pedestrian, arguments of Thaddeus Story, gravely pedestrian and peripheral. He says the EC's action was extremely perverse. Would you say the judge appeared too emotional in his judgment? Is it regular for judges to use this kind of language when they are addressing counsel?
Well, I have read many judgments, and some of them tend to also express their sense of outrage towards bring the case to the court in the first place, and perhaps they would have wished that the lawyer either would have advised the party not to go to court, or even if they would go to court, then the lawyer wouldn't be a person who was sitting himself with it. Lawyers, and there are many cases even given by the Supreme Court recently, have been advised to use language that is quite measured, even against our colleagues. But for the court, it is quite usual for the courts to express their outrage at why a lawyer would have advised someone to come to court. But in this case, we can handle the judgment without necessarily having to concentrate on some of those words. I think that is something we can do. I can tell you for a fact that I think the lawyer and the judge, there shouldn't be any problem between them. It is just the judge delivering judgment and certain words they have used. This, for me, doesn't take away anything from it. But I, by practice, even when I'm filing an appeal, we usually mention a judge's name and we just say that maybe the court judge. I think that in building on these matters, it may be necessary, perhaps sometimes, either as a lawyer attacking the decision of a court, may not want to mention the judge's name, or perhaps may not have to mention the lawyer's name.
And I know you
can still, pardon?
I know you don't have too much time, but I can't afford not to ask this question. Can the other presidential candidates who were disqualified, i.e. Ayariga, Dr. Edward Mahama, Nana Konedu, and the rest, Danlate's son, can they wake up tomorrow morning or Monday morning and then go to the EC and say, on the basis of the judgment that was delivered in Papa Kwesi Ndum's case, we believe that we have a right, it has accrued to us, give us an opportunity to amend our nomination papers, and then accept them?
Well, I'm not sure I'm permitted to give them a gratuitous advice. They have lawyers, and I think they have all the full facts. So they may advise them on the right procedure or step to take from now on.
Do you see this judgment as opening the floodgates for everyone else to get onto the ballot paper?
Well, each case will have to be looked at on case-by-case basis. If and mind you, it's not a Supreme Court decision; it's a High Court decision. It doesn't other High Court, maybe of persuasive value only, but the decision as to whether or not these are all other persons that have defined can then also take a cue from the judgment and advise them. So that would be a good decision, and it will be also up to the EC to either continue to apply the law strictly as we understand it, be influenced by this decision and any other advice. Otherwise, well, I think that the others will still be inclined to pursue matters at court. And I think that all of us must ensure compliance with law, whether by going to court or by applying the law as we are permitted to do.
Okay, I know I said that was my last question, but this is my very last one.
Never mind, go ahead.
Do you see this judgment as constituting sufficient grounds for one to question the credibility and integrity of the EC?
I don't think so. I mean, we all are entitled to apply the law as we understand. Where other people disagree, they go to court. It is the court that has the final judicial power to determine whether or not, in applying the law, I made a mistake or misconstrued.
But if the EC took a decision that the judge said was extremely perverse, because looking at his own regulations, Regulation 9 of CI 94, it should have been obvious to the EC that Dr. Indum was entitled to a right to amend his documents. If the EC failed to adhere to such a basic law, it should raise questions about the EC's motives.
Well, I don't think so. My friend, understanding the law may not be as easy as that. I mean, you're surprised that this decision may go on appeal, and some other people, maybe the court, the Supreme Court, may also disagree with him.
Do you see that happening?
Well, it is not for me to determine. I think that it is for the parties. After all, one of the parties threatened that if they had lost, they would have gone to the Supreme Court. But I'm saying that we are talking about law. If we don't encourage people to question the law itself, then we cannot develop the law. So it is for all of us to question the law, disagree with the law, but comply with it until it is otherwise set aside. But to say that just because the EC may have misconstrued or misapprehended the law, that is perverse. Strictly speaking, I cannot remember hearing the judge use that word.
He said it. It's in the judgment. I just read it.
But then leave that as these ones only are, if you are against to the ratio, that is the important aspect of the decision. Now we shouldn't allow them to have a cloud the main ratio, that the important facts and the law that we should extract from the judgment. The bottom line is the EC thought they were doing what is right, but the court says they were not doing what was right. That is as simple as that.
Before I let you go, let me just read what the judge said. He said the conduct of the returning officer and the commission in its denial of the right afforded the applicant by law to make alteration or amendment to his form has been taken in a petulant fashion, and their decision in respect of the applicant has been extremely perverse. This is what the judge said. But we are most grateful to you for the enlightenment that you brought to this discussion. Thank you. Yawapong is a law lecturer at the Faculty of Law, Central University. I have to take a break. When we come back, I'll come to my guests in the studio who have been waiting patiently to have their bite. You're watching PM Express. We will be back. You're welcome back. You're watching PM Express, and we are discussing the High Court's decision ordering the EC to allow Dr. Papa Kwesi Ndum of the PPP to amend and make alterations to his nomination papers and resubmit them. My guests are Mr. Odru and Mr. Dorpo. So, Drew, I rudely interrupted your discussion, but you just heard Yao Pong saying, in his view, this judgment really doesn't touch upon the integrity of the Electoral Commission. Do you agree?
Well, I agree. I agree to the fact that the integrity is not affected. But
really,
I would want the EC to also take a look again at its stance. I mean, what the EC projects today, particularly its key stakeholders.
If your own regulations say give somebody a chance to amend their nomination papers, if they have a problem or one of their subscribers or their subscribers have problems, and you do not do that, that's basic to the extent that the judge says your decision is extremely perverse.
Well, that could be deemed to be a bit harsh. But I would want to look at it from the perspective that, you see, the EC is dealing with the emotions of the whole country. Public elections in our country, we all must understand, is not just a simple administrative task that is carried out and everybody goes home happy and all that. It carries with it a lot of emotions. And you would always expect the electoral body to present itself as being open, fair, just in all its dealings.
Has it done that for you so far?
Well, I mean, if we have to just take this case, and even yesterday's the Supreme Court's ruling.
And Abu Ramadan's 1, 2, and 3.
You see, if you keep on getting these kind of knockbacks, it doesn't help. You see, yesterday, let me even chip in a comment made by the Asante Hene yesterday concerning the EC's failure to regulate its own laws to the extent that we have seemingly too many mushroom political entities operating in the country. You see, if we want to be fair, let's be fair. But even being fair does not preclude an administrative body to also have, I mean, I don't want to use the word God, but the engagement with the key stakeholders must be friendly, must be warm, must be based on mutual respect, and then there mustn't be any issue of suspicion. Now we have these parties there. You disqualified a candidate. The candidate has gone to court and the court has ordered. You see, it starts chipping on your credibility. I wouldn't say there's a fatal attack on the EC as of now. But then if it keeps on, you keep losing case after case after case, and a public stance is taken. For instance, I'm an independent body and you cannot order me. Then the court says, go and do ABC. Like the Supreme Court, they say that we will not allow you to do ABCD to the country. And today you go and say, I'm an independent body, and then the courts tell you that, yes, we have a supervising role over what you do as an administrative body. I would hope the EC will do an introspection and come back and engage its key stakeholders. At the end of the day, it is our democracy that will be the better off than if the EC takes a stance that seems to be, well, we are who we are, you can't touch us. But I think sometimes even dialogue can help.
Has the EC come up for you as an institution determined to be fair and truthful and honest and balanced in its dealings with you?
Oh, not at all. To be very honest with
Since
you.
when? Since when? Just in fact, on this matter?
No. You know that it is the PPP that has been calling on the EC to apply all the rules, including all that the Otumfuo said, making sure that political parties in good standing must have their offices in 2/3 of the districts in the country, that audited accounts would be presented to the EC, explaining the sources of our funds and so on and so forth. So we were shocked that we had been advocating for the implementation of all these rules. Then the EC decided to deny us opportunity that we should be given as part of the rules, and then gave the impression that we were rather not law-abiding.
And the judge said that the denial of that opportunity is even more fatal and incurably bad.
Well, that is what makes me even think that the EC's conduct is not only extremely perverse, but I would say it was thoroughly perverse and wicked. Why? Because it means
because you're not the only person.
No. It means that
presidential candidate that was disqualified.
Malik, in my appreciation of this whole democracy and governance and good governance thing, and our collective effort to make sure that we establish and entrench democracy in this country, it has not crossed my mind anywhere that there is an institution that would deliberately go out there to exclude somebody from participating in our democracy. What the EC did by excluding without giving hearing, for me, is strange. It's strange and extremely biased.
Do you honestly believe that all of these are the presidential candidates, and we hear a lot of them, that all of them should be on the ballot paper?
Well, I think that would be an unfair question to me, because the rules are there. If they meet the requirement, why not? But we know that the EC failed.
Is that a bastardization of our democracy?
No.
If you have 17 presidential candidates.
Well, are they all in good standing? No. How many of them have offices in 2/3 of the districts? How many of them have filed their audited accounts? No. So, in fact, the burden is on the EC to operate the law fully and not to pick and choose. Now, it's important for us to say this, that the conclusion that the EC reached was that Dr. Indium's nomination fell short of one subscriber. That was the conclusion. So we are very clear in our mind what we must do by way of alteration. So this issue about doubts about whether his name will be there or not, we are very clear in our minds.
And the EC's lawyer tried to argue that to the extent that you had Richard Asida endorsing your forms in 2 separate districts across 2 regions, there was some criminality.
Well, that is why we think that the EC was up to something diabolic. EC collected all the 4 documents, 4 sets from us, and kept the documents for 10 days, and returned them after the 10th day, only to tell us that there is a fault. How would you know whether it was our fault or somebody tampered with it when it was in possession of the EC? So that matter is a completely different matter.
You didn't make this argument in court.
Well, because it was not necessary. What was necessary, because you see, EC attempted to mix it up, and indeed, our opponents were flying the issue of criminality and so on and so forth. If somebody indeed engaged in criminality, we know where to go. That does not affect somebody's inalienable right to be voted for.
To be fair to you, the judge argued that the matter before the court was not about criminality.
Certainly.
The matter before the court was Sheshararai.
Absolutely.
And you are arguing that your natural right, every human being has a right to be heard. No human being should be condemned unless their right to be heard has been offered and an opportunity to explain has been offered. And your argument was this right was not given you.
Certainly. Now, that's why I would respectfully disagree with Lawyer Opon that EC was only interpreting the law as it understood it. Look, EC has the benefit of institutional memory. There are so many other commissioners there who have worked with Dr. Farijan, who has operated and conducted himself in this accommodative way because they themselves know that when it comes to operating the law in total, they are not ready to do so. So then you have this, and I believe sincerely that the problem is with the new EC boss. Who must take her time to learn, because she got excited about the fact that somebody has registered or somebody had endorsed the forms in one region and endorsed in another region. So she was carried away by the prospect of catching somebody engaging in crime. But that is not the crux of the matter. The law says when somebody, and the CR 94 provisions are very clear. It said if it does not fit according to law. So if it falls short by one subscriber, it is not fit, it is not acceptable according to law. Then you are enjoined. It said you shall invite the person in question to undertake an alteration. But she was so blinded by the fact that somebody had made a mistake. But all along, we had not been working with the EC in this manner. And so her behavior is becoming difficult. Now, in conclusion, let me tell you, we believe that the EC's credibility is at stake. Seriously at stake. Because they have exhibited bad faith, and the lawyer came in there to even add up to it. That is what the judge was describing. If you were supposed to do something before punishment, that is hearing, and you failed to do so, but you went ahead to exact punishment, then the person says, if you give me 5 minutes, I can explain. Then you come to court and try to say that is hearing, please. So the EC, obviously, for us, the EC's credibility is really at stake.
Zodwa, do you share William's view that the EC chairpersons, Mrs. Charlotte Osei's disposition and approach and response to some of these things may have played a part?
Well, I wouldn't even want to dare go in that tangent, because it would be very, very unfair on the person of Mrs. Osei, because she is one of the commissioners. And in fact, she told Dr.
Ndumda that the decision, she recommended it, but the decision was upheld.
Absolutely.
By
she is the chair of the commission. Yes, she's the first among equals. And she is naturally the face of the commission. You see, there is also the danger. As much as I'm celebrating that we must celebrate that rule of law has won the day. That somebody was not being treated fairly. The courts, that we have a system that allows, if you are not being fairly treated, to be given the opportunity to do. I'm very happy for Dr. Ndium to be back on the ticket if all the processes are complete and he's back. But I will be very hesitant to condemn the personality of the Mrs. Osei.
Okay, let's move away from that. Do you think the inclusion of Dr. Papakwesi Ndum on the ballot paper does anything for the elections in terms of the dynamics of the electoral outcome, the results?
I do, but not only Papakwesi Ndum. There are a couple of other people I would want to see on the ballot.
Edward Mahama of the PNC?
Absolutely. I mean,
do you want to see Nana Konadu of the NDP?
Well, I'll be happy to see her as well. You see, let's be very frank in this country. Unfortunately, we are having some people appearing as presidential candidates who don't have any business being there. You see, if we do that...
Do you want to mention names?
You want me to mention
Dr.
names?
Henry Latte?
Well,
Hassan Ayariga?
Please.
Ekweodonko?
Let me get Malik. Let me get back. Let me get back to, you've mentioned Dr. Indium, you've mentioned Dr. Edward Mahama, you've mentioned Nana Kunedu Ajman Rawlings. You see, let me be very factual. Yes, Dr. Henry Latte might be another person you might want to look at. You see, please, where in a serious, he himself has ruled himself out, so he's not even in contention. Where in a serious democracy can you find 13, 15, 16 people on the ballot sheet? Moreover, people will come and speak to you and you ask yourself, is this person serious? We are talking about democracy. The president of a country who is going to make critical decisions. You see, I don't want to look down upon anybody. It's unfair. But we all have our different strengths. So if you, as a human being, you cannot even sit back and say that this is my capability and this is what I can do for my country, then even your failure to assess yourself fairly is even an indictment on yourself. It shows that obviously you don't know what you're talking about.
So you don't want to see all of these guys on the ballot paper?
How can, even if we assemble the top 20 people in the country, I don't want to see the top 20 people on the ballot. We shouldn't have that. It only tells us we are not a serious democracy.
There are those who believe that the PPP was being pushed out because it would have created a problem for some other candidates. The absence of
Malik,
Dr.
would you be prepared to give me evidence to that effect?
There are those who argue that if Indum was not on the ballot paper, it would inure electorally to one or the other presidential candidate. You don't share that
My
view?
analysis doesn't show that to me.
There are those who say if he is on the ballot paper, he can push the election to a runoff. And if the election goes for a runoff, it doesn't favor one candidate. You don't share that as well?
I don't share that because in the last election we had, what was the percentage of all the various groups?
It's been 4 years down the line.
So let us see what happens in this election. For
One party has been in power for 2 terms. Another party has been out of power for 2 terms. I mean the major ones. So a lot has changed.
You see, I think that we must start looking at our electoral rules as to who can even go on the ballot.
Who will benefit from Indum being on the ballot paper? Akufo-Addo, John Mahama.
He's going to take from all of them if he's there.
Who will lose most?
I can't tell. Because as we speak now, what is the stronghold of the PPP in the country? You and I cannot say that's the stronghold. You see, the PPP appeared for the first time last time.
And
they were able to, they came third, but with what percentage?
A distant third.
A very, very far distant.
But they still beat the CPP and the PNC
very
and all
good.
the rest.
So they are building up. I would want to give the PPP the opportunity of 2016 election. Then we can start assessing them. Where are they picking their votes from? Is it from the key parties, the MPP and the NDC? Let's admit, the MPP and the NDC are the top, the front runners. But we have what I would want to look at as the Nkrumahist table. Although I know Mr. Dopo will say we are not Nkrumahist. But
how do you know I'll say that?
Oh well, I mean I've heard PPP.
What they always argue is that they are not. They didn't break out from the CPP.
But we need to analyze from where are they picking their votes. Then we can be very fair in our analysis that indeed they are chipping away from the 2 main bigger parties, or they are still eating from the little that the other parties.
Since the man is here, let me ask him. Are you in this race to cause trouble for any of the major parties?
Well, for all of them. There's trouble for the NDC, there's trouble for the NPP. Why? Because something big is going to happen December 7th. And from January 7th, something bigger would happen. And that one will be positive because the reforms towards transformation will begin when we get into government. And I should say that our message is gone down well.
I don't mean overly optimistic.
Our message is gone down well because we've managed to convince the people of Ghana that reforms must come first for change and transformation to happen. And what are these reforms? They're just about 3-4 of them.
Okay, so he's going to give us the PPP's manifesto.
No. But then it's very important that having an independent public prosecutor in this country will turn things upside down. The positive. Election of MMDCEs will change the political and governance landscape.
NPP and NDC are promising election of...
No. We don't have time.
Election
but
of
then,
DCs.
But then
NPP is promising independent prosecutor.
NDC's promise is to have 5 people nominated by the president.
That was in
fact,
the 2012 manifesto.
Bottom line, they are going to maintain the status quo because they are going to have 5 NDC people and then they go through that process. It comes to the same thing. It won't change anything. As for the NPP, we are very, very doubtful about it because they had 8 years to do it. They are putting the manifesto, they did not do it. So, in a nutshell, I'm saying that something big is going to happen. And about our stronghold, we are picking votes from every corner of this country based on the work that we have done. So, yes, 2012, we're just 8 months old. We started in February, and then we contested in December. Now, we are over 4 years old, and we've been around, and very strongly. Now, there is this conspiracy theory that our troubles are as a result of the fact that some people fear that once Dr. Indom appears on the ballot paper, the status quo will change. The top dogs will lose their lead, and they would be completely overtaken. That is the belief of some people.
Do you share it?
Absolutely.
Okay, you hold that thought. Let me pick a few comments from some of our viewers. This one, the judiciary is the third arm of government. Their decision must be respected. So to safeguard our society, I am only worried. A court has ruled that a fraudulent act resulting from forged signatories be corrected and left at that. As for Dr. Ndum's chances, I pray he gets more votes than spoiled ballots this time around. I love Ghana from Barima Kubaji. There was no question about forged signatories. That has to be put on record. This one says, the way things are going, with the EC, I'm compelled to think that either the chairperson is not taking the advice of the other 6 commissioners who have more experience than her, or they have decided to allow her to do whatever, to allow her to mess up. This is Alaji Looms, Yendi. Let me see this one. Hi, I see the EC's decision. Hi, the EC needs to ensure a peaceful elections for peace to prevail in the country. This is Amwa Kwasari, Chufuheman. Many more. Good evening, Mr. Host. EC is losing almost all the court cases against it. It raises questions about its credibility to deliver this time around. Indeed, Mahama Shalataza and the EC must stop Yentie Obia attitude and listen to the election stakeholders and give us free and fair elections for change. This is Madleon Ahafu Fidim. You just heard some of the people saying, well, they think that the EC is not listening. Others believe that your party is not going anywhere. You shouldn't get more votes. You should They are hoping that this time you will get more votes than spoiled ballots. But I don't think we have too much time left. I have to say thank you to Mr. William Dorpo. He's a PPP's parliamentary candidate for Ayawa's West Wugon. And then Mr. Odru is from the Institute of Local Governance. He's a governance expert. He's a lecturer as well. Thank you both, gentlemen, for coming. God willing, we will bring you another exciting discussion on PM Express. Until then, my name is Malik Abbas Dabu. Bye-bye. Good to see you. Good to see you.
Thank you so much.